Hello and welcome to episode 11 of the Parliament Podcast. I'm your host, Andy Segadin, online managing editor for TLR Review Volume 91. On today's episode, we welcome Margaret Gallagher Thompson, Vice Chair, Private Client Services at Cozen O'Connor. Margaret will be discussing how the Tax Cuts and Jobs Act has influenced her practice and her clients' tax and estate planning. This will be my last episode of the podcast. I would like to thank the Volume 91 editorial board, our generous guests, and everyone who listened in despite my voice for print. As always, I hope that you find our conversation with Margaret to be informative and enjoy. We're thrilled to welcome Margaret Gallagher Thompson to the podcast today. Margaret served as executive editor for TLR Review Volume 61 and is currently vice chair, private client services for Cozen O'Connor, just up 76 in West Conshohocken, where she specializes in tax and estate planning for high net worth clients. She's here today to talk a little bit about tax law and the impact of the new tax bill from last year. So without further ado, welcome Margaret. Thank you for joining us.
Thank you, Andrew.
So before we get off to the I guess the good stuff, I usually do like to ask our guests about what they remember from TLR Review and how things might have changed. I guess, do you have any particularly fond memories, stressful memories, anything like that from your time on North Broad Street?
Well, I guess enough time has passed so that some of the anxiety that we certainly always felt with respect to the notes and getting the issues out, kind of passed. So I feel as I look back on the time with great fondness. I really enjoyed the writing. I had great editors, and then when I was executive editor, it was a lot of fun. It was exciting to get those issues out, and so I have a lot of fond memories of it.
And you were, correct me if I'm wrong, you were a staff editor. I know a lot of us are familiar with Judge Rice because he still teaches evidence at Temple, but you were a staffer when he was editor in chief, correct?
Exactly. He is the best.
Moving on to, I guess, some of the work that you do, I know that some of us, myself included, were in Tax One last spring, just a few weeks after the Tax Cuts and Jobs Act was signed. This supposedly wasn't as drastic as an overhaul as in 1986, but certainly a lot did change. And I understand again that your practice focuses on gifts and inheritance and etc. So I guess when you first read about the changes in the bill, or maybe even read some of the provisions, what did you expect in terms of impact? And I guess how has that played out in the past year plus?
Well, I think that, for us, the big impact was the increase in the exemptions for gift estate and generation skipping to 11.1 million at the time, and then double that for a couple. And so in the larger trust and estates community, I think that generally there was a certain amount of concern, like what's this going to mean for us? Are we going to be out of business, so to speak,
Mm-hmm.
because many of our clients would no longer have the need for the kind of planning that we do. But it really hasn't worked out that way, and certainly at my firm, Cozen O'Connor, we have, our clients are still within the estate tax regime, notwithstanding these changes. So it has not been, those concerns that maybe hit the larger community have not really played out for us.
And I guess I'd imagine, I want to get to that point in a minute. I think in a few questions we're going to hit exactly what you were just talking about. But I'd imagine, and maybe ignorantly, that I guess there's a routine, obviously, in your practice. I know there's been incremental changes over the years that you probably keep abreast of, and I guess you kind of monitor that and kind of implement that with your clients along with your colleagues. I guess, was this a little different because it was all at once? And I guess how have you mentioned that you were worried about some of the changes. I guess how did you adjust to some of the changes in the past year?
Well, surprisingly, we have had some very large changes over the last 8 years. We had in 2010, the estate tax went away entirely for a year, and that really threw everything
Mm-hmm.
up in the air. And then we had a huge change. It may not sound as huge, but we had a period in 2011, 2012 where we thought the exemption might go back down to 1 million, and we just raced around doing gifting in that year,
Mm-hmm.
and really were extraordinarily busy, and that really impacted us. This is a huge impact But interestingly, as dramatic as it is, by increasing the exemption, it provides us with more opportunities, and also we've got some time. You know, we're
Mm,
not in a huge rush to make sure that everything happens, you know, in this calendar year. That may come to us, as we may discuss later, but
sure.
that's not there now.
And I know you mentioned we will discuss, I guess, the 2025 later. But I guess does that, I guess, talking to the point you're making right now, does that help in a little bit? Because you said earlier that in some cases this was year to year stuff. So at least while there might be some volatility down the line, at least you know you have 6 years. Does that make a difference?
Well, it does make a difference. It certainly made a difference this year, as people adjusted to their new exemptions and started to think about what they might do and how they might handle it. Um, but that the pace will start to increase dramatically as the years go by. I mean, we're going to be keeping a close eye on the political situation. Um, you know, whether after next year's elections, whether we see any changes that might come in ahead of the 2025 deadline. So we are definitely keeping our eye on that, and I expect that we will have some very, very busy years coming up, one way or the other.
Okay. And one of the things that you talked about on the outset was a concern that, hey, these, so for instance, the estate tax doubled to just shy of 23 million for married couples. You mentioned, in some ways that's great for the taxpayer. In other ways, that might make certain services, not as needed, not as sought after. I'd like to hit some of the specifics, and the first thing is that estate tax law, which I just mentioned, is now just shy of 23 million for married couples, and there have been commentators who, I guess, and you appreciate when you just mentioned the election, there is some political ideals about this. Some people don't understand the estate tax at all. They call it a death tax. They say that it really shouldn't be anything, and it hurts small business. But then I also read a statistic recently from the Center of Budget and Policy Priorities that only 80 of the 8 million small businesses and family farms in 2017 paid the tax, and that was back when it was about 11 million for couples. So, as a practitioner, what does this? You mentioned that there's some concern about the increase hurting business. That hasn't happened. I guess why hasn't that happened? And are clients still, I guess, seeking this? Is this still a concern for clients when now this is obviously in another stratosphere in terms of the exemption?
Well, the reason it hasn't impacted my practice and the practice here at Cozen is just because we have very high net worth clients who
Okay,
are still in the estate tax regime, notwithstanding this large increase. I think that it probably has impacted attorneys who are working with clients even um, in the $5 million range. Not that we don't have those clients, we
sure.
do, but that's not our bread and butter. And so our clients, yes, still continue to be interested in in many of the same types of techniques that we've used in the past to try to reduce their exemption. They're just in a better place than they were before.
Okay. And I guess along those same lines, I guess another thing I probably read about more than any in terms of gift and inheritance and whatnot is I guess various vehicles that people are looking to use to pass along their wealth with minimal impact to future generations. And I've seen a fair amount of guidance on dynasty trusts, which I understand is a
Right.
vehicle in which you can kind of gift portions of the family business under the gift tax threshold that you mentioned earlier, and also probably more than anything, grantor retained annuity trust, which I'm probably going to over-explain and inadequately, but basically it allows taxpayers to place investments in a trust for a few years, take back their investment and the interest, and then the gain is given to the grantor tax-free. Have you seen a rise in these sorts of vehicles, and where do you, I guess, see things trending in terms of what clients are looking for? What do you anticipate being popular now as compared to what was popular in 5 years, that sort of thing?
Well, I think that we have been using dynasty trusts, which allow assets to pass through the generations without taxation, and the grantor retained annuity trusts, which are basically a freeze of the asset and just getting the growth out. We've been using these for a number of years, and we continue to use them. They're still quite popular, and we still use them. One of the things that we see in more recent years is with the increased exemption, we can say to our clients, obviously you can be gifting a much greater amount than you could before without gift tax consequences because of the 11 million and then the 22 million for a couple, and clients have to really come to terms with that, whether they are comfortable parting with such large amounts, even though it is fine to do from a gift and estate tax standpoint. So one of the things we've seen rising, it's been coming for a couple of years, but we're definitely seeing a good bit of it, are what we call SLATs, or spousal limited access trusts. And these are trusts where a person might make a gift, a very significant gift, using up most, if not all, their exemption to a trust for their spouse. It uses up their exemption, thereby freezes the amount, the growth there, but allows an independent trustee to, if need be or if desirable, to make distributions to the spouse. And that gives our clients some comfort making these larger gifts, because people are always like, well, how do I know in 20 years am I going to be able to do without these funds?
Sure.
At this level. And so a spousal limited access trust is one technique where the person can have some comfort that if something is needed, it could come back in. Obviously, that's not the goal, but it does provide a level of comfort with these very large gifts.
And I guess, do you see, and just kind of follow up on that, do you see, I guess, more, I'm sure that was a big part of your practice just by the nature of the work that you do beforehand, but in terms of like family dynamics and I guess not even financial plan, but family planning and I guess planning for the future, do you see more of that now in your practice because of the large sums that can be gifted, or has that kind of always been the case and it's stayed that way?
Well, I think that the dynasty trusts and the grants have been a staple for a number of years, and I can't say that we're doing more. We do a lot of them, and we continue to do a lot of them. And these are techniques that are in our toolbox for really all of our clients in terms of discussion. So I can't say that has increased more, but rather some of these things that we're trying to do that give the client comfort in parting with such large amounts.
And speaking of parting with very large amounts, and it's something that I guess I've had personal interest. I've followed this a little bit, and you probably can educate me in ways that a couple of Google searches can't. I guess I'm curious about how charitable giving plays into all of this, because I've followed this a little bit, and I know that charities, when the tax law first was adopted, were concerned because of the standard deduction doubling. That obviously one of the, not main, but certainly a motivator of some people is that there'd be a tax break in giving, and now with the standard deduction, a lot of middle tier givers might not give as much as they used to. While at the same time, there's been also thought, okay, well, the high net worth clients might give more. So I know that there's been some vehicles out there. One being, very popular, at least as I've seen it, is the donor advised fund, in which case, again, I'm going to oversimplify, but basically the taxpayer is able to pay into it, get the full deduction now, and then I guess disperse funds over time. Basically, they have this big fund, and they can kind of direct it as they see fit. And I guess some people think this is great. It allows people who might not otherwise be able to give to kind of stack their giving. Maybe they can't give all at once, but maybe they could do over a 3-year period and get the deduction. Others, I know Boston College's Ray Madoff has been very vocal about this, have criticized it as a sort of workaround that doesn't immediately help charities. I guess, have you seen these sorts of giving vehicles rise in prominence? And I guess, how have the new tax laws impacted how your clients are asking you about their giving plans?
Well, I have seen a tremendous rise in the donor advised funds as a vehicle for our clients, and our clients still are extremely interested in charitable giving because of the federal estate tax deduction that's still out there. It's still a very important way to reduce the taxable estate. Now, the other thing that we do see with our clients, and this gets to your point, I think, about the donor advised fund, is that our clients are also very interested in not only their own giving, but in developing habits of charitable giving among their children.
Hmm.
And so a donor advised fund and or a private foundation is another alternative, are ways to do that. And both of those techniques involve making large gifts that will to the foundation or to the donor advised fund that will come out in small increments. A private foundation, for example, only has to distribute 5% of its net investment income each year. So that's not a huge, or
Hmm.
excuse me, 5% of its distributable assets each year. So that's not a huge distribution that's going out. But and so that may get to the point that Ray Madoff is making. But private foundations are extremely popular, but they are extremely expensive to operate. They are governed by very strict tax. Provisions. And so, what people have started to turn to is the donor advised funds, because the donor advised funds are really easy. I mean,
Hmm.
you open an account and you get to decide, working with the investment institution, whatever it might be, where those distributions are made. It's true they don't come out all in one fell swoop; they come out over years, but it kind of gives the benefit of the private foundation without the tax returns and the tax responsibility that goes along with it, and get the kids involved. And so we have found that they're popular, and I think they're I don't think there's any. I don't see the negative to it, because people have been doing the same kind of thing with private foundations
Hmm.
in terms of large gifts going in and into the foundation, and then smaller pieces coming out as grants from the foundation. So I think they're a great alternative, and they are popular.
And correct me if I'm wrong, the donor advised fund, you can pass that along. Say you have this donor advised fund and you pass away. I guess your heirs are able to distribute those funds. Correct.
That's right. That's right. You can name the successor advisors. Each institution has its own nomenclature for it, but basically, whether you call it advisor, custodian, owner, but each, you can name your successor,
Hmm.
and we've seen that done very successfully.
And I think also, I think to your point with the foundations, I think there's a 5% minimum on the foundations. I don't think that's the case for donor advised funds, but I think if you look at, I think like I know like Fidelity and like Schwab post their statistics, and I believe it's basically typical, maybe a little higher than the typical foundation rate.
That's right. That's right. Now, foundations can also distribute more than that,
Sure.
um, but and just as donor advised funds can. But yeah, the donor advised fund is treated as a public charity for tax purposes, so it's a more flexible vehicle.
Now, one of the things that I guess I'm just churning out my ignorance during this conversation. One of the things that I haven't heard that much about with the new tax law, but I think it is interesting to hear, I guess, how you interact with it. I know in our previous conversations you've talked about it a little bit. Is I guess how federal tax law interacts with state tax law. And I know, for instance, Pennsylvania the average Joe can take employee expense deductions in their state return that no longer are available in the federal tax return. And I guess probably more relevant to your practice in our conversation is the inheritance tax that exempts spouses and charitable organizations, but unlike federal law, does tax recipients of after-death gifts. I guess are there differences? Are the differences now between federal and state tax law starker than years past? And I guess how do you and your colleagues, I guess, kind of lay out both? I'm assuming you're working with as you mentioned very wealthy clients. I'm sure their tax considerations are much more complicated than the average Joe. I guess how do you kind of lay it all out and see, I guess, what path is best?
Well, I got to tell you, you are correct that the differences between the federal and the state system of taxation for estates is starker now with the increase in the exemption. When we had clients with a $20 million estate and they had a $10 million exemption, they were still going to pay a lot of a lot of federal estate tax at 40%.
Hmm.
It's a huge hike, and so in that environment, the Pennsylvania inheritance tax, for example, which is 4.5% on transfers to descendants, it seemed like a drop in the bucket. But interestingly, um, now that the federal estate tax is hitting at a higher rate, that same couple with $20 million is not going to pay any federal estate tax, and they are really, now they're looking at this 4.5% Pennsylvania tax, which has no exemption,
Hmm.
like the 11 million that we have for the federal, and it really still takes a nice chunk out of the
Sure.
estate, even though it's only 4.5. So it's looking a little more difficult now, or a little more onerous now than it did back in the day, although it hasn't changed. And we certainly have clients, we've always had this, but we still do, clients who consider changing their domicile in order to avoid the Pennsylvania inheritance tax, as well as the Pennsylvania income tax. So we have clients very interested in our area in Florida as a change in residence, because they can eliminate not only the income tax but also the inheritance tax. Florida not having either of those,
Hmm.
so it is important to the clients, and I think more so now.
And that inheritance tax, I believe, I think the 4.5% actually can go up to, I think, 11 or 12%, depending on who you're giving the money to. Correct?
That's right. That's right. So it goes up to 12% for siblings, and then 15% for everybody beyond
Oh
that.
wow.
And so that is a huge nut. And of course, we do have clients, like everybody does, who maybe don't have children and maybe are wanting to give to nieces and nephews. It's a huge hunk.
And I know we were talking about this before, and I know it's not necessarily in your wheelhouse because, again, you focus more on a state and whatnot. But I know we had talked previously about some states being concerned, not necessarily because of the estate tax, but because of the state and local exemption leaving, because of the rise of property. I guess worries about flight from high tax states to low tax. So you're seeing that already in your practice, or at least interest in that in your practice already.
Definitely. Definitely.
That's interesting. Um, I guess before we wind down, I do want to touch on I think one of the elements that we started about earlier when we were first talking. I guess one of the quirks about the Tax Cuts and Jobs Act is that the individual tax rates expire in 2025. And I've seen guidance on this as it relates to how high income families are preparing for retirement, perhaps paying taxes on tax deferred vehicles now as opposed to later, so that they can basically get maybe what would be more favorable rates now and then not have to pay taxes once they actually take the money out during retirement. I've also seen some concerns about the exemption cap for generation skipping transfers potentially
Right.
go down from where it is now, which I think is about 11.4 million. I guess how do you see, and I know you were talking about this before, and how you expect this to be a very busy next 4 or 5 years. I guess how do you expect the next, these few years to play out in terms of A, what clients are preparing to do in 2025, and B, I guess what do you think is going to be the outcome in 2026, 2027 once these, what we currently have is gone?
Well, you know, my hope is that Congress will take some action so that it won't go away. And one of the other things that we look to historically is that the federal estate tax, when I say that, the exemption for gift, estate, and generation skipping all together, really hasn't gone down. We've
Hmm.
had threats of it constantly, and we hear, and if you open the newspaper today, you'll see some candidate talking about getting rid of it sooner rather than later, getting rid of the exemption, I mean, sooner rather than later. But so I don't know what the future will bring. I really don't. I keep coming back to the fact that it's really hard to take away something that's already been given,
Hmm.
and so I don't. I'm not sitting here thinking that it is going away, but nonetheless, we will be in high gear, and if things look uncertain, which it will probably come down to the wire. If there's been any experience that I've had over the last 8 or 9 years, it's that generally these things come down to the wire, and we'll be encouraging our clients to utilize that exemption. We got some IRS guidance within the last year telling us that if you utilize your exemption and it goes away, you won't be penalized. In other words, you won't die and somebody say you've only got 5 million of exemption
Okay.
when you ended up using 20 million. So, so we've gotten that guidance from the IRS, and so we are going to be um, uh, getting into some very, very serious gifting, and we will be advising our clients to use their exemption as the time goes by.
And do you feel, and I guess just to follow up on that, because I know you've mentioned a few times how 2025 is the date, but there's been talks about dating back to 10 years ago about things going away, coming back every year. I guess, do you feel as though now maybe as compared to earlier in your practice, things are more politically volatile, and thus the tax law is the same way, or has it kind of always been a year, a Congress to Congress type of thing in terms of what you have to work with?
Yeah, I mean, we've always. I must say that in any given year that we're in, when we're in the year, it feels very volatile.
Okay.
Um, but uh, but this the political situation that we're in right now seems exceptionally volatile. I mean, when you see the the disconnect between the parties, um, it's who knows what could happen if Congress turns around or it turns over in 2020. Might something happen even sooner? You know, as I said, I haven't seen this. I haven't seen the exemption go down, but I guess it's possible.
And then one other quick thing. I guess you mentioned the IRS guidance. I guess how has that been? I guess has the IRS been, I guess, quick with guidance in the past year, or have you kind of been playing catch up a little bit?
I think we're always playing catch up with the IRS,
Okay.
and I think that for them, the law was very difficult. It was complex and multifaceted, and they were, it basically gets dumped on the IRS then to figure out how to administer it. And certainly, we saw on the income side um, some issues um, with people having withholdings that were not sufficient and so forth, and just really, it really has been a lot for them to process in such a short time. But I will say that we were glad to receive this guidance about the exemption in the last, since the law has been enacted, and that is moving, I guess I would say, moving fairly quickly and really helpful to the clients.
Perfect. And I think that answer, I guess, leads into our final question, which is kind of a catch-all that we'd like to end our conversations with. I guess a wise young lady a few years ago once told me that what's really interesting, what's really kind of cool about tax law, and why some people kind of get sucked in. If you're a tax lawyer, you can be nothing else. You kind of get sucked into it. Is that it kind of depicts what America values. If you want to encourage certain behaviors, we give a tax break for it. If we want to discourage things or curb things, maybe we don't give a tax break to it. I guess for somebody who's devoted a large part of your career to tax, to estate planning, I guess what do you find most interesting or most exciting about the work that you do and tax law in general? And I guess what would you tell a young lawyer who is maybe looking at this as an option?
Well, I think that, as I noted earlier, um, when you're dealing with high net worth individuals, in my practice, it's just a tax driven practice. But the beauty of it is, I really, you got to kind of get into the tax code, kind of be a tax nerd a bit. You got to enjoy it because it really does. It's changing constantly, not just the kind of changes that we're discussing, but daily um, pronouncements from the IRS, rulings, procedures, guidance are coming down from the IRS, and we need to be constantly aware of it. And it's a bit of a maze. But the beauty of it in my practice, because I'm a trust and estates lawyer, is my clients are individuals, they are families, and I really I feel a lot of personal satisfaction
Hmm.
about being able to use my interest in taxes in a way that I think can be helpful to people and helpful to solve the maze of trying to provide for their families in the way that they wish, at the same time to do that in the most tax efficient way. So I find it very rewarding.
Beautiful. Well, Margaret, thank you so much for joining us. It was really a great pleasure speaking with you.
Same with you.
Take care.
Bye.